Morenike, can you tell me a little bit about yourself and what inspired you to want to become a lawyer?
Sure. So I'm a senior counsel here at Legal Defense Fund. I'm based in the New York City office. I would say I'm a generalist, so I have some cases that are in all four of our pillars: political participation, economic justice, criminal justice, and education. But I am aspiring to do more economic justice and housing work because a few jobs ago, I was a tenant attorney in Brooklyn where I did eviction defense work and also affirmative litigation on behalf of tenant associations and groups of tenants. And I would really like to be doing more fair housing work here as well. And then, in terms of what inspired me to come to LDF, one of my mentors and former supervisors at my last job started his career here at LDF, and he said it was the best job that he'd ever had and that it was a great place to do really cutting edge and exciting litigation on behalf of Black and other marginalized communities. And that sounded like something that would appeal to me.
And how's it going so far?
I think it's going okay. Yeah, I think there have been a lot of changes with the political landscape in the last year. And I think personally and professionally, still sorting through what that means for the type of work that I can do and how I can be best of service to the communities and issues that I'm most concerned about.
So let's start out with one of the cases on which you are, I believe, main counsel or lead counsel on, that was filed this year, the New Hampshire Indonesian Community Support versus Donald Trump, with a coalition of civil rights group. Can you talk about what is this case about and why did LDF join this coalition?
Yeah, so this case is a case that we filed on behalf of three organizations that have individual members, many of whom are immigrants and other non citizens. And we are challenging the Birthright Citizenship executive order that was one of the first executive orders promulgated by President Trump on Inauguration Day. And the main takeaway from the executive order is that it's attempting to change the definition of birthright citizenship and who can avail themselves of the right of birthright citizenship by requiring that if you were born after January 20th, both of your parents need to be lawful permanent residents in order for you to get the benefit of birthright citizenship. That has never been the case before, but that's what this new executive order says that came down on January 20th
So January 20th of this year.
of this year. Yes.
Yeah, 2025.
Inauguration Day. Yes. So we brought suit with a coalition of other civil rights organizations to challenge the lawfulness of this executive order, saying that it directly conflicts with the 14th Amendment, which is very clear about the right of birthright citizenship and really only has very few limitations on who can become a birthright citizen. And it also conflicts with what's called the Birthright Citizenship Statute, which is a federal law enacted by Congress and reauthorized, which essentially codifies birthright citizenship as it's understood in the 14th Amendment.
Okay, so let's break these things down. Let's first start with this January 20th, 2025. Trump issued an executive order and it was called Protecting the Meaning and Value of American Citizenship. What does the executive order actually say about birthright citizenship?
So the executive order creates a new definition of what it means to be a birthright citizenship. The language of the 14th Amendment doesn't have the same limitations that are included in the executive order. So the executive order starts by focusing not on the person or child who is going to be born, but first on their parents. And so it's limiting which children can become birthright citizens based on the immigration status of their parents. It says if your mother was not a lawful permanent resident, or if your father was not a lawful permanent resident at the time of your birth, and you're born January 20th or later with a 30-day implementation kind of window, then you won't be able to be a birthright citizen. You won't be an American citizen.
So it makes your citizenship contingent upon your parents' status in the
Yes,
United
that's right.
States. And you have to be a lawful permanent resident, not a citizen as a parent, in order for your children to be citizens.
Yes, you don't have to be a citizen, but some have some sort of lawful permanent residency in the United States.
Okay. And how does that conflict? What does the 14th Amendment birthright citizenship, what does that clause actually say? And then how does it conflict with this executive order?
So the birthright citizenship clause of the 14th Amendment says essentially anyone who's born on United States soil and within the jurisdiction of the United States, which I'll get to what that means, is a birthright citizen. It doesn't say anything about the immigration status or any other status of that person's parents. It's just if you were born here under the United States jurisdiction, you can become a birthright citizen. And that's how the practice has been for the last, going on 200 years since the 14th Amendment was enacted. The jurisdictional element limits things in the case of, let's say, you were born outside of the territory of the United States. You won't be a birthright citizen in that case. Or you were born on U.S. soil, but to two parents who were both diplomats. Or there are some other very limited circumstances that has been developed in case law. But by and large, everyone who's born in the United States can be and is, upon birth, an American citizen.
And so you mentioned that there's also a statute that complements the 14th Amendment. What is that statute and how does it come into play with the case that is in New Hampshire?
Yeah, the statute contains essentially the same language as the 14th Amendment. It was initially enacted in 1940 and then reauthorized about a decade later. And it has the same thing, basically, except for these very limited exceptions. Every person who's born in the United States is an American citizen. And for our case, it's another basis for challenging the lawfulness of the executive order in addition to the 14th Amendment.
And so you have the 14th Amendment and then you also have a statute. So can you explain how an executive order can overturn the Constitution and also this statute that has been enacted?
Well, our main argument is that it can't do that. For the 14th Amendment, in order for there to be a new definition of birthright citizenship, either Congress needs to amend the Constitution, or Congress and the states actually amend the Constitution, or the Supreme Court says we're overturning hundreds of our own precedent to say that the 14th Amendment's birthright citizenship clause means something completely different than what we previously said, and then how all other courts have been interpreting it. Or on the statutory piece, Congress would have to amend the birthright citizenship statute to include the limitations that are in the executive order. But either way, the executive order cannot on its own override the Constitution or federal law.
So it seems like there's a pretty big hurdle in order to overturn the 14th Amendment and amend the Constitution or the statute that has been put in place.
Yes, we believe so. We believe so. Every court at the district level and also at the appellate level that has reviewed the legality of the executive order has invalidated it. So we feel pretty strongly about the fact that the executive order is just completely unlawful.
And so when we talk about, we have the case in New Hampshire, but there are cases across the country. Can you talk about how all of those cases are connected with the litigation in which LDF is involved?
Yeah, there are at least 4 other cases that were filed shortly after Inauguration Day, so earlier this year, late January, early February. There are 2 in Massachusetts, there's 1 in Maryland, and there's also 1 in Washington State that are all challenging the legality of the executive order. We largely have the same claims and legal theories, but there are some minor differences in that regard. And as I said, each one of those cases has been successful in invalidating the executive order.
And I know you have been working with different groups of people on the amici strategy. And so I was wondering, specifically in working with historians, why did you bring historians into the fold for this case? And what role do they play in helping to explain, the 14th Amendment?
Part of the government's argument, or the federal government's argument, in arguing that the executive order is lawful, is that it's the true correct way to interpret the 14th Amendment, based off of scholarship from around the time of the amendment's enactment that is advocating for a more limited definition of who can become a birthright citizen and conditioning birthright citizenship on the parents having some sort of close ties to the United States. In the government's briefing, they use the word domiciled, which is a legal definition, which basically means this is the place that you intend to live and remain for a long period of time. So that's the argument that they're putting forth. And we thought it was very important to have historians submit an amicus brief in favor of our position to show that, in fact, the Constitutional Convention that considered the 14th Amendment discussed the possibility of having a more limited definition of birthright citizenship and rejected that and said that it doesn't matter whether or not your parents have a lawful permanent residency status, whether they're just passing through the United States on their way to somewhere else. If you are born in this country, then you are an American citizen.
That's very interesting. Can you talk about whether the historians connect the birthright citizenship clause to the overall historical context of Reconstruction that was occurring when the 14th Amendment was ratified?
Yes, the historians definitely did connect the meaning and understanding of the 14th Amendment to what was happening at that time. So this is shortly after the conclusion of the Civil War that was fought about whether or not slavery can exist throughout the United States, among other issues about states' rights and federalism. So that's definitely something that is happening in the backdrop. At the same time, you have at this point, over a century of activism from formerly enslaved and currently enslaved people really pushing and fighting for the fact that there shouldn't be 2 tiers of citizenship. There shouldn't be, 2 social classes essentially based off of whether or not someone is, a white landowner versus a Black person or a person who is formerly enslaved. And so the people who were voting at the Constitutional Convention at that time were shaped and impacted by all the things that were happening and felt very strongly that, given the context of the Civil War, if they didn't have a constitutional amendment protecting citizenship for formerly enslaved people, that it could be very likely that a new Congress could come in and put us in a position where formerly enslaved people could not be citizens or wouldn't be able to avail themselves of certain constitutional rights. So it was a very deliberate choice to say, we want to ensure that we don't have this 2-tiered system forever. There's obviously the historical caveat of what the reaction to that was, and kind of how short-lived the project of Reconstruction was and the backlash to that, and obviously setting us down the path for, separate but equal and de jure segregation. But at the time, that the 14th Amendment was being ratified. Certainly the aim was, let's ensure that really as many people as possible can become birthright citizens.
And so, with the oral arguments across the country, have any of them or the judges' questions kind of addressed the history behind the 14th Amendment? Or most of the cases, are they just addressing the injunction relief, the technical part, procedural part of the case?
Yeah, I think that's a good question. I think that at least for our oral argument that took place in the First Circuit Court of Appeals in Boston, it was much more squarely focused on the case law. So there's a Supreme Court case, Wong Kim Ark, that is really the controlling precedent for what birthright citizenship means. So that was more of the focus. Focusing on the Supreme Court's analysis and reasoning there rather than the framers' intent of the 14th Amendment, because I also think that the historical background is pretty clear, actually. If you
Mhm.
look at the debates at the Constitutional Convention and you read through them, it's pretty clear they discussed the possibility that this could apply to people whose parents were only in the United States temporarily. And you can see different members of Congress explaining that, yes, I know that that could happen, but we think it's worth it.
And so, have people in terms of opposing counsel usually have they used the word, this is an originalist argument when they are making the arguments about how the 14th Amendment should be interpreted?
That's a good question. I don't know that they have characterized it as originalism, primarily because that even just evoking that word is probably not likely to be well received by the particular judges that they are arguing in
Mhm.
front of. When we get to the Supreme Court, I think that's a different story. But in terms of the different district courts and appellate courts, I don't think that really leaning on originalism to explain why the executive order doesn't conflict with Supreme Court precedent from the 19th century, information from the um, Constitutional Convention, I don't think it would really carry the day.
And so, let's turn to, as an attorney, what are your thoughts about this? Two very contrasting viewpoints of what the 14th Amendment stands for. One where you see, directly in the constitutional conventions that um, the 14th Amendment is clear and should apply to all persons born in the United States, versus the, you know, the administration's view. What impact does that have kind of more broadly on our democracy and how people see themselves within our democracy?
Yeah, I think first thinking about it as an attorney, we do have an obligation to make legal arguments that, have a good faith basis in the law and in reality and that are not frivolous. And I think that there is a question of where the line is between, oh, I'm throwing out something here that's creative and I am advocating for a position that is not defensible. So that is kind of my first reaction to the executive order and the fact that we are having to litigate this issue and having to debate this issue and having to remind people of the history and the clarity of the history. And then I think the second issue or thing to think about is kind of the debate between originalism and I think what some folks call like the living constitution. And with originalism, what the framers and founders of this country believed and think shapes everything that we're doing today in a way that is static and cabined based off of their lived experiences and what they knew in the 18th century versus an idea that the Constitution is meant to be a document that has breathing room. It's a document that's meant to grow and expand based off of how our country has changed and developed. over the last hundreds of years, and that we as Americans in 2025 should not be cabined with the way that we live and the rights that we can have based off of the perspectives and imaginations of people almost 300 years ago who would never have envisioned so many things that are happening in our country today. One of my dreams for this specific moment is that immigrants in this country, regardless of their immigration status, would be able to live fully realized lives without the fear of the terror of immigration enforcement authorities coming to their home or their job or their children's school, and to not be exposed to the violence that our federal immigration system imposes on families of immigrants every day, and not to be exposed to the violence that these raids and arrests, particularly arrests that are happening as people are within the halls of immigration court, to not be exposed to that terror and anxiety, and to also not be met with the vitriol about immigrants and, frankly, people of color in this country and who we are and why we're here. For us to just really live in peace with our families.
If I could ask one more question. With your dream, how is your work on the New Hampshire case part and parcel of kind of realizing that dream?
Yeah, I think that work is part of pushing back on the federal government's attempts to just remake our immigration system and remake our immigration law by trying to restrict the number of people who can become birthright citizens. Because I think the purpose, or one of the purposes of the executive order, is to try and deter people who are not from this country from coming here, to limit the number of new Americans and American citizens that can be born, and to try and, harken back to a time when the demographics of the United States looked very different. So I feel very strongly, and I feel very honored to be working on the birthright citizenship litigation here at LDF as a way to push back on that in the courts, but also with the narrative work that we're doing with the amicus briefs, the historian's brief, but also the other brief that we helped organize regarding the impact that the executive order will have on Black immigrants and their families as well.
Anything else, Morenike, that we haven't covered that you would like to be in the podcast?
I don't think so. Yeah. Thank you for thinking of me and for giving me this opportunity.